Hello, my name is Professor Vidya-mitra. The name of the module is Treatment of Victims and Recourse to Innocent Parties. Module Overview. This module will provide a detailed discussion about the recourses available to the victims of armed conflicts. It will also talk about the protection granted to the innocent parties and their remedies in case of breach of such protection under the international humanitarian law. Further, the module lists in detail the people who fall under the category of protected persons / innocent parties and gives examples on how in various cases IHL has worked towards the protection of such innocent parties. Learning objective. The objective of this module is to make the readers understand the importance of international humanitarian law in treating the victims of armed conflict. This module also works towards developing an understanding of the types of rights and remedies available to the innocent parties like children and women in case harm is caused to them as a result of the conflict. Introduction. The Charter of the United Nations states, I quote, "All members shall refrain from the threat or use of force against the territorial integrity or political independence of any state." This means that all members of the United Nations are to refrain themselves from indulging in any activity which may harm the territorial integrity and political independence of any state. These guidelines are not necessarily followed. Wars and conflicts are bound to happen. Whether it is the war or conflict between two independent states or within the confines of an individual state, the fact is that these incidents cannot be absolutely deterred. However, international institutions like the United Nations and the Red Cross seeks to minimize the loss caused by armed conflicts. In the contemporary wars and conflicts, innocent civilians majorly constitute the victims and at times have been deliberately targeted. The most vulnerable amongst them are women and children who are killed, raped and sexually abused, kidnapped and enslaved, and children who are taken and forced to become soldiers. In 1980s, the Ethiopian army would kidnap boys of 15 or younger from the villages and the poorest quarters of the cities, as well as from schools to engage them in the activities of war. The survivors of these atrocities are displaced and they end up taking refuge in camps. More deaths of the innocent take place because of the indirect effect of armed conflict, that is disease, malnutrition and famine. The ever increasing number of wars has demonstrated the need to strengthen the protection of victims of international and non-international armed conflict. Civilian protection has been the main motive of the United Nations peacekeeping mission since the end of Cold War. But instances of mass violence like the genocide in Rwanda in 1994 puts a doubt on the ability of the United Nations to protect non-combatants. The gist of the basic principles of international humanitarian law with regard to victims and innocent parties can be summarized as follows. Or number 1, the non-combatants, persons who are not or are no longer taking part in hostilities shall be respected, protected and treated humanely. Appropriate care without any discrimination should be given to them. 2. Captured combatants. Captured combatants and other persons whose freedom has been restricted shall be treated humanely. They shall be protected against all the acts of violence, in particular against torture. they shall enjoy the fundamental guarantees of a regular judicial procedure. 3. No unnecessary suffering. The parties to a conflict have a limited right to choose the methods or means of warfare. No unnecessary suffering shall be inflicted. 4. Distinction between civil and military target. In order to spare the civilian population, armed forces shall at all times distinguish between the civilian population and civilian objects on the one hand and military objectives on the other. Neither the civilian population as such nor individual civilians or civilian objects shall be the target of military attacks. While the above stated general principles apply to all kinds of warfare, there are specific principles and conventions for internal armed conflicts and international armed conflicts. Treaties and conventions. The main conventions that deal with the protection of victims and the innocent parties of war are as follows. 1. Article 3, common to all 4 conventions of 1949. All people who are not taking part in hostilities should be treated humanely. 2. 4th Convention 1949. The 4th Geneva Convention of 1949 governs the treatment and protection of civilians in times of war. Part 1 and Part 2 contain the general provisions for the protection of civilians. Provision for neutralized zones, protection of wounded and sick, family news, child welfare, etc. have been taken care of in this part. The third part talks about the states and treatment of protected persons vis-a-vis aliens in the territory of the parties to a conflict in occupied territory, regulation for treatment of internees, Information Bureau and Central Agency. 3. The protocols additional to the Geneva Convention of 1977. Protocol 1. Additional Protocol 1 of the Geneva Convention of 1977 is relating to the protection of victims of international armed conflicts. The whole protocol is divided into 6 parts. Part 4 entails the protection provided to civilians. The first section from Article 48 to 67 talks about the general protection of the civilians against the effects of hostilities. The second part, Article 68 to 71, gives specific relief to the civilian population. The last section, Article 69 to 71, deals with the treatment of a person in the power of the parties to a conflict. It has provision for the protection of women, children and journalists. Article 48 is the distinction between civilian population and combatants and civilian objective and military objective. Protocol 2. Article 3 is common to all 4 Geneva Conventions of 1949, was the only provision applicable to non-international armed conflicts before the introduction of the additional Protocol 2. The aim of the present protocol is to extend the essential rules of law of armed conflicts to internal wars. Part 4 of the protocol, Articles 13 to 18, talks about protection of the civilian population in times of internal armed conflict. Civilians can be defined as those people who are not or are no longer the part of the armed forces. The protocol also includes protection of the civilian population, Article 13, protection of the objects indispensable to the survival of the civilian population, Article 14, protection of workers and installation containing dangerous forces, Article 15, protection of cultural objects and places of worship, Article 16, prohibition of forced movement of civilians, Article 17, and relief societies and actions, Article 18. Principles and guidelines. In 2005, The United Nations General Assembly adopted the basic principles and the guidelines on the rights to a remedy and repatriation for victims of gross violations of international human rights law and serious violations of international humanitarian law, referred to as the principles and guidelines. They reflect the current state of international law on remedies and repatriation for the victims of armed conflicts. Practices. Before moving further, let us see who all are covered by the international humanitarian law under the category of protected persons. The treaties and the conventions of the IHL protect those in need. The IHL gives the status of protected person to children, civilians, missing persons, prisoners of war and detainees, refugees and displaced persons, women, wounded, sick and shipwrecked. The practices towards those protected persons are categorized into the protection given to them and the remedies available. Number 1. Protection. Children, apart from the status of civilians or combatant, the international humanitarian law recognizes the vulnerability of children and grant the special protection under the law. 1. Children carrying arms and directly or indirectly taking part in the armed conflict had become a serious humanitarian issue, especially in Africa. Apart from playing a direct role as a child, soldiers, innocent boys and girls are used as cooks, porters, messengers, spies and for sexual purposes. These roles are sometimes intentionally taken because no other resort is left to sustain the livelihood. The 1977 additional protocols to the Geneva Convention prohibit the recruitment and participation of children under the age of 15 in hostilities, international armed conflicts. The first additional protocol also requires military recruitment of 15 to 18 years old to prioritize the oldest. 2. The children who are not involved in armed conflict are supplied with medical help, food and clothing. Orphaned and separated children are meant to be identified, protected and provided with special facilities to ensure their physical security. Also, their children who are detained are to be treated humanely according to the provisions of the convention. Civilians. IHL ensures that civilians are treated humanely in all situations. They must be protected against all forms of violence and degrading treatment, including murder and torture. Moreover, they are entitled to a fair trial in case of prosecution. The protection of civilians extends to those trying to help them, in particular medical units and humanitarian or relief bodies providing essentials such as food, clothing and medical supplies. The 4th Geneva Convention additional protocols specifically requires the parties to a conflict to facilitate the work of the ICRC, while IHL protects all civilians without discrimination. Certain groups are singled out for special mention. Women and children, the aged and the sick are highly vulnerable during armed conflict. So too are those who flee their homes and become internally displaced or refugees. IHL prohibits forced displacements by intimidation, violence or starvation. State must also help the civilian in tracking and bringing back the displaced and lost family members of the civilian population. Then is the refugees and displaced persons. First of all, it is important to understand who refugees are. According to the 1951 Convention relating to the status of refugees, a refugee is someone who A. has a well-founded fear of persecution because of his/her race, religion, nationality, membership in a particular social group or political opinion. B is outside his/her country of origin, and C is unable or unwilling to avail him/herself of protection of that country or return there for fear of prosecution. The refugees are protected under the 4th Geneva Convention and the Additional Protocol 1. The international humanitarian law guarantees access for relief and humanitarian organization to refugees and the IDP, that is, internally displaced people, in situations of armed conflict. Parties to a conflict must facilitate the supply of relief materials such as medicines, food, blankets and tents. Women. Women are one of the most vulnerable groups of a conflict. They must be protected from sexual violence, which includes rape, forced prostitution and other forms of sexual crimes, which also constitute war crimes. The general provision of IHL also forbid women being taken as hostages and used as human shield within the provision for food, clothing and medical assistance. Evacuations and transportation. IHL further requires that expectant mothers and nursing mothers be treated with special care. Relief available to the victims. In order to ensure the success of international humanitarian law, it was essential to make provision to proper enforcement of the law. According to the basic principle and the guidelines on the rights to a remedy and repatriation victims of gross violation of international human rights law and serious violations of international humanitarian law. Principle 8. Victims are persons who individually or collectively suffered harm, including physical or mental injury, emotional suffering, economic loss or substantial impairment of their fundamental rights through acts or omissions that constitute gross violations of international human rights law or serious violations of international humanitarian law. Where appropriate and in accordance with domestic law, the term victim also include the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. Principle 9. A person shall be considered a victim regardless of whether the perpetrator of the violation is identified, apprehended, prosecuted or convicted, and regardless of the familial relationship between the perpetrator and the victim. Principle 11/23 covers the various types of reliefs available to the victims of the gross violation of the human rights law and the serious violations of the international humanitarian law. These can be summarized as follows. Restitution, Principle 19, restore the victim to the original situation before the gross violation of international human rights law or serious violations of international humanitarian law occurred. Restitution includes, as appropriate, restoration of liberty, enjoyment of human rights, identity, family life and citizenship, return to one's place of residence, restoration of employment and return of property. Compensation, Principle 20, and compensation should be provided for any economically accessible damages as appropriate and proportional to the gravity of the violation and the circumstances of each case resulting from gross violation of international human rights law and serious violations of international humanitarian law, such as physical or mental harm, lost opportunities including employment, education and social benefits, material damages and loss of earnings including loss of earning potential, moral damage, costs required for legal or expert assistance, medicine and medical services, and psychological and social services. Rehabilitation Principle 21. Rehabilitation should include medical and psychological care as well as legal and social services. Satisfaction Principle 22. Satisfaction should include, where applicable, any or all of any of the following: effective measures at the cessation of continuing violations, search for the disappeared, abducted bodies of those killed, and assistance in the recovery, identification and reburial of the bodies according to the cultural practices of the families and communities. Public apology, including acknowledgement of the facts and acceptance of responsibility. Commemorations and tributes to the victims. Guarantee of non-repetition. Principle 23. Guarantees of non-repetition may be provided in cases by ensuring effective civilian control of military and security forces, of ensuring that all civilians and military proceedings abide by international standards of due process, fairness and impartiality, strengthening the independence of the judiciary, protecting persons in the legal, medical and healthcare professions, the media and other related professions, and human rights defenders, promoting mechanisms for preventing and monitoring social conflicts and their resolution. The critiques. Application. The protection of civilians provided by the Geneva Convention and additional protocols is extensive. The problem of the next 50 years has been application. Neither states nor non-state armed groups have respected the obligations adequately. Civilians have continued to suffer extensively in almost every armed conflict. In some conflicts, civilians have been specifically targeted and subjected to terrible atrocities, ignoring the very basis of the Geneva Convention, respect for the human person. It is for this reason that the ICRC continues to press states to respect and ensure respect for the principles of IHL, especially the protection of civilians. Refugee flow. Regrettably, these rules have been ignored in many recent conflicts, putting both refugee populations and IDPs in danger. The ICRC has consistently called on states and non-state armed groups to respect and ensure respect for international law and the basic principles of humanity when dealing with civilians. Only through respect of the rules of armed conflict can refugees flow and internal displacement be prevented. Similarly, if people have to leave their homes, they can only be protected if IHL is complied with. Now, there are two case studies. The first case studies is of Sierra Leone. In the Sierra Leone Civil War, which was in the years 1991 to 2002, the atrocities and the violence inflicted on the citizen was huge. A large number of child soldiers were abducted and inducted in the rebel army by the rebel group, Revolutionary United Front or RUF. The victims of the war have ghastly accounts of the encounter with the war. In 2010, the President of Sierra Leone formally apologized to women victims of his country's 10-year armed conflict. This apology forms part of efforts to distribute modest compensation, rehabilitation and other benefits to eligible victims. Also, the victims of gross human rights violations were paid compensation averaging USD 80 per victim as a part of various programs aimed at repatriation of the victims of the conflict. The second is Kosovo. In another situation of Kosovo War 1998 to 1999, various reports say the victims are not being adequately compensated. The Kosovo War was fought between the forces of Federal Republic of Montenegro and Serbia and the Albanian rebel army. For Serbia, the ethnic group of Albanians posed a huge threat due to their desire of independence from Serbia. During the war, thousands of people were injured and killed by the security forces. However, even after 14 years of the conflict, the scale of rehabilitation and compensation is very low. While the Serbian government denies the commitment of the crime, Kosovo government is not fulfilling its obligation towards the victims. The rehabilitation work that is going on is run by the non-governmental sections with the assistance of international donors and limited support of the government. A number of problems remain unaddressed and victims uncompensated. Thank you.